This is Court Watch with Alex Sawyer, and I'm excited to bring you the 9th episode of my podcast, where I am joined by Professor Robert Tuttle, who teaches law and religion at George Washington University. Professor Tuttle is a legal scholar specializing in the First Amendment religion clauses, who chatted with me about his expectations in the case Groff versus DeJoy. It involves a former post office worker who sued the post office after he was forced out of his job for not working on Sundays. The dispute was heard by the High Court on April 18th over the post office declining to accommodate Mr. Groff's religious observance due to his evangelical Christian faith. Package delivery 7 days a week became an issue for him when the Postal Service contracted with Amazon to make deliveries on Sundays. At first, Mr. Groff had volunteers pick up his shifts, but when no one was available to fill his void, he would be penalized for not showing up to work. It eventually became such a problem that he resigned in 2019. He sued the post office for not accommodating his religious rights. The justices will decide to what extent an employer must accommodate an employee's religion. At issue is a case from 1977, Trans World Airlines versus Hardison, where the court ruled an employer could discharge an employee who sought to observe his Sabbath, which was on a Saturday. Professor Tuttle talked to me about if he thinks the justices will overrule the 1977 case, or if they'll issue a different type of opinion, maybe clarifying the requirements employers must meet in order to avoid religious accommodations. Hey, Bob, thanks so much for taking time to sit down and do our podcast here. I really am anxious to hear your thoughts on how the Supreme Court handled the arguments in the Groff dispute, because I am looking back at my coverage from last week, and usually when I'm in the courtroom, I can kind of gather maybe where a majority of the justices are leaning in a case. I remember from my coverage and being in the courtroom, I had a hard time. I didn't think there was exactly a line in terms of the questioning that I thought was like definitely on Groff's side or vice versa. It seemed like they were trying to figure out, for example, like what happens, they mentioned when other employees need to take time off, like a Sunday, they want to spend time with their family, that sort of thing. So they seemed worried about that. I wanted to hear your take.
I think you're right to be confused about a lineup, because in religion clause cases or religion clause related cases, this involves Title VII, the employment discrimination law, and the requirement that employers have to accommodate the religious needs of employees unless it causes an undue hardship. And the big dispute is about what undue hardship means. So this is in an important sense a religious liberty case. But in most of the religious liberty or religion clause cases of the past, 30 years that I've been following them, you can figure out a pretty clear line between the justices, and you, with the exception of a couple of them, you can predict pretty well what's going to happen. And that is certainly true with decisions over the last 5 or 6 years, that it was easy to see what the lineup was, with one exception, and it's really close to this case, and it's the Philadelphia Catholic Charities case involving
the foster care?
Right, the foster care, and whether Philadelphia had discriminated against Catholic Charities by excluding them from their foster care program. And the difficult. Well, first off, the difficulty in figuring out how to line people up in that case tracks almost perfectly, not quite, but almost perfectly, with the difficulty in figuring out how to line up people in this case. So on one side, you have the liberal justices, or more liberal justices, who are very much in favor of the Solicitor General's approach. And they say, they agree with the SG and say, let's just affirm the Third Circuit. Let's uphold the finding that Groff's rights under Title VII were not violated by the Postal Service's refusal to give him his requested accommodation of having every Sunday off. The reason that they want the court to just affirm the Third Circuit is that it doesn't require the court to announce a new test that the Solicitor General rightly fears might upset the way that over the past 50 years since TWA versus Hardison, which is the case that is in a sense at the center of this case. It's a mid-1970s decision in which the Supreme Court held that undue hardship meant no more than a de minimis burden, which since the time of the decision has made those who favor religious liberty outraged because they believe that it means the duty of accommodation in Title VII is essentially stripped away. If more than de minimis is undue hardship, then there's really no undue hardship.
Mm-hmm.
The Solicitor General focuses the court's attention on footnote 14 in the TWA case, which I think is very important because too many people focus on the undue hardship language. And it's not really the court's ruling. The court's ruling is based on the facts at hand, based on the facts of that particular request for an accommodation, which would have required TWA to upset the collective bargaining agreement and especially its preference for seniority in determining days off. That would be the cost of it, and it would potentially imperil TWA's smooth activities because it would create a serious breach with its labor union.
Let me ask you for clarity real quick. You said you referenced footnote 14. So I think didn't Justice Kavanaugh bring that up during arguments, if I remember right?
Absolutely. Justice Kavanaugh brought that up.
I was going to say, was the question, he kept saying something about like a substantial cost to the employer.
Right.
Was that specifically what the
footnote? That is what the footnote says. That's what the footnote says. So TWA versus Hardison does not really stand for a rule that says no more than de minimis hardship. TWA versus Hardison stands for a very contextual decision based on all of the facts, and the court throws around a variety of terms. And that's what Justice Kavanaugh picks up. He picks up the language of substantial hardship. And what the Solicitor General tries to explain is that the language of the text of the statute says undue hardship. Footnote 14 adds substantial, and substantial concern has been included in all of the EEOC's guidance material for employers. So the EEOC did not take no more than de minimis and run with it.
Mm-hmm.
Instead, they took a much more conservative reading of the court's opinion and said all of the facts matter and that the real standard here should be when does providing an accommodation impose a substantial hardship. And that has been the way that they, at least according to the Solicitor General and according to a number of the briefs, that's the way it has worked. But those who are strong advocates for religious liberty have used the de minimis language to attack, first off, some district court opinions that got it wrong. And you can imagine with lots and lots of accommodation cases, there are going to be some cases that get it wrong. It's just going to happen. And sometimes the review at the circuit level is not adequate, or nobody files an appeal. So it's never corrected. So there are some cases out there that say no more than de minimis and use that as the language, but that's not the guidance that the EEOC gives. And I think what's important from the Solicitor General's perspective is that addition of a new standard to govern. That is this is part of what Justice Kavanaugh, Justice Gorsuch, Justice Barrett were asking for. So that now we get to the middle three justices.
Mm-hmm.
What they were asking for is a standard that could more clearly articulate what the EEOC is actually doing. Now, what's the practical effect of that? Well, Hardison would be modified instead of left intact. So the court's decision in Hardison would be modified. Okay, so is that a big deal? Well, it returns the case to the Third Circuit to reappraise the facts of this case under that new standard. And the Solicitor General says, look, I don't think it would be any different, but here's the problem. If you suggest that you have now created a new standard, you have courts all over the place that think they have to interpret a new standard instead of using the guidance that EEOC has provided them for 45 or more years on this. And that the Solicitor General suggests would be deeply destabilizing. So we have three in favor of keeping the Hardison ruling intact and making it clear in the court's opinion, making it clear that they are doing so in reliance on the EEOC's long time practice of giving guidance that amounts to the full language of TWA versus Hardison, not focused on this de minimis.
You mentioned Justice Barrett and Justice Kavanaugh. I think there's also like a line of questioning too, where they asked about like, you know, if they were to rule for Groff, essentially like how would that put employers also in a situation where they're kind of prioritizing one religion over another? Yeah,
there is an interesting line that I don't really think goes anywhere in the decision. Where is this question? There's this question about potential competition among faiths, and I just don't see it playing. I mean, it's hard for me to see how that's going to lead any place in the decision. What I think we're likely to have is Justices Gorsuch, which is a bit of a surprise because he's usually with Scalia and Thomas and Alito on this, and but Gorsuch and then Kavanaugh and Barrett. And if you remember in the Catholic Charities case, Kavanaugh and Barrett sided with Chief Justice Roberts and the liberals on the court to make a very narrow ruling that still said Catholic Charities was protected, but avoided making an entirely new and broad rule for religious liberty.
Yeah. So you're kind of thinking, I'm gathering from what you're saying is you don't think this is going to be a full win for Groff where they overturn Hardison. You think it's going to be more like a narrow ruling.
I think there's no chance that Groff wins. Little to no chance that Groff wins. I think there are only 2 and maybe 3 votes for Groff. The Chief Justice was very hard to read in his questions. Yeah. And I wasn't sure what to make of that. But Justices Thomas and Alito were very clearly on the side of Groff and Groff's lawyer Strat. And they reasoned that the meaning of undue hardship should be taken from the standard under the Americans with Disabilities Act, which is significant difficulty or expense, which is a very high standard to meet for employers. That significant difficulty or expense. Now, there's a reason the standards are different. I should just go ahead and give the reasons that they think the standard is appropriate. That Congress has come along and given some meaning to the term undue hardship in subsequent statutes. And so they think that it would be appropriate to borrow from this statute. All of those on the liberal side, and I think Kavanaugh and Barrett as well would strongly disagree because of this. The court has a tradition of what's called statutory stare decisis. So stare decisis is the principle of
respecting precedent, right?
Respecting precedent, right? Well, there's an even stronger principle of congressional or statutory stare decisis. And the idea is that once you make a decision interpreting a statute, Congress has every opportunity to amend the statute immediately, right? And it happened in the mid-1980s when when the Supreme Court ruled that military personnel could not wear religious head coverings, even if they were entirely covered by their military uniform cap. And Congress came back the very next term, I think the next fall, I think it was just a matter of months, with a statute that said, yes, they can. So, that the principle of of statutory stare decisis is very strong, and the court rarely holds that that its prior interpretation of a statute is wrong, because it assumes that Congress has acquiesced, that is, Congress has agreed with the decision, especially in a context as here, where Congress has made numerous changes to that statute, but has not touched, despite significant pressure. And as someone pointed out, bills being introduced over a more than 20-year period, consistently attempting to change the interpretation of that provision of Title VII to require a stronger standard for employers like significant difficulty or expense. So I think that Groff's attempt to have a stronger standard imposed on employers has little to no chance of getting 5 votes. Mm-hmm. But what I don't know is what happens with the middle. Mm-hmm. And by the middle, I mean Justices Kavanaugh, Barrett, and Gorsuch. If they ultimately side with the Solicitor General and agree that you can write an opinion that simply clarifies the meaning of TWA versus Hardison, doesn't overrule it, doesn't distinguish it, just clarifies the meaning, and doesn't create a new standard, but simply says, we see the way that EEOC has been interpreting this. We read TWA versus Hardison in its broad interpretation and give due weight to its wording in footnote 14. And so you can write this in a way that doesn't say TWA versus Hardison needs a new rule. Or,
right.
We need a new rule, right? So you can write it that way.
I was going to say, I think leaving the arguments, that's kind of what I gathered. It seemed like that's kind of where, at least Kavanaugh, like the middle of the court, seemed interested as giving some sort of clarification on that substantial cost, for example. Right.
The question is, when does the clarification become a new rule? Mm-hmm. That's the really difficult question here, is when does the clarification become a new rule? And I don't know. I don't know how to answer that question because I don't know how they'll write it. But my guess is they will not want to unsettle all this law if the plaintiffs, despite some amicus briefs that said people had bad experiences with the EEOC, that the plaintiffs did not adduce a lot of evidence of misuse of this standard. Mm-hmm. And so I I don't know whether that was plaintiff's obligation, but nonetheless, that was Groff's. That would have been in the work that organizations supporting Groff needed to do, which was to give some sense of the number of times that courts have ignored the EEOC guidance on this. And I don't think that evidence is out there. But again, I don't really know. It's hard to tell how the court will come out. It will not come out in favor of Groff. The only question is whether it comes out in favor of the existing interpretation of Title VII, mm-hmm. or whether it suggests that so much clarification is required of TWA versus Hardison that we are effectively announcing a new rule that incorporates the term substantial. Mm-hmm. Yeah. And if that's the case, then it does, I think, throw things into a bit of disarray, but not necessarily disarray in a way that would end up favoring Groff. Mm-hmm. I still think it's likely that Groff himself would lose on the merits.
Let me ask you. Oh, go ahead.
Go ahead.
No, finish this line of thought, because I was going to ask you my last question, and maybe if you want to touch on this after you finish what you were just saying, is, you teach and study this line of jurisprudence. How often does Sabbath cases come up?
Well, I will go ahead and answer that, and then come on. The Sabbath cases have come up a surprising amount because even before, back in the late 1950s, early 1960s, there were a number of cases back when we had blue laws enforced broadly. Blue laws, you're probably too young to know, but blue laws were laws that closed businesses on Sunday. Mm-hmm. And Orthodox Jews filed claims first that those constituted violations of the Establishment Clause because they privileged Christian Sabbath, and then they filed claims of free exercise because they wanted to open on Sunday because their faith forced them to close on Saturday, and they wanted to be treated equally. And the courts, the Supreme Court was sympathetic to neither of those claims. Then, in one of the first cases challenging the validity of an accommodation of religion, called the State of Thornton versus Caldor back in the early it might have been 1980, was a case that occurred when the blue laws were eliminated in Connecticut, and a store manager said, "Well, it's against my faith to work on Sundays," and and the statute said, "You're right that any store that stays open on any store that chooses to stay open on its Sabbath, any store that has employees that claim a Sabbath day when the store is open must give that employee relief." And the court said, "No, you can't do that. That violates the Establishment Clause because it privileges the religious interests of employees over other relevant interests, including those of the workplace." And that case came 3 or 4 years after TWA versus Hardison. But one of the things that's interesting in this decision is the sense that justices, especially Justice Alito, questioned the Solicitor General on the extent to which her new interpretation of TWA versus Hardison took into account the relevant changes in current Establishment Clause law. In other words, the idea in the 1970s would have been that the government must be neutral between religion and non-religion. But now we have a very different Supreme Court, and the requirement of neutrality between religion and non-religion is completely gone, and we could see that in a case like Hobby Lobby under the Religious Freedom Restoration Act, in which Justice Alito, of course, ruled that religious businesses were entitled to certain exemptions. There's no obligation to extend those same exemptions to conscientious but non-religious businesses or individuals. And so the idea that religion can be treated differently, religion can be treated better. Because if religion is treated differently but worse, that violates the Establishment Clause. But if, that violates the Free Exercise Clause. But if religion is treated differently but better, there's no violation of the Establishment Clause unless it, we don't know what the boundaries are, so I'll just leave it at that. But preferential treatment of religion, in other words, instead of having some kind of balance, the Establishment Clause prevents religion from gaining some kinds of benefits that may be funding by the state, but it gives religion other kinds of benefits, that is exemptions. That balance or symmetry is entirely gone now. And so that was the question that Justice Alito particularly asked the Solicitor General. And the Solicitor General made a very, very good argument. He said that Tigre versus Hardison nowhere references the Establishment Clause as the reason for its limitation on the scope of hardship for businesses. Even though I think that's why it did it. And Estate of Thornton versus Caldor explicitly references the Establishment Clause, but Estate of Thornton versus Caldor involves a very different kind of required accommodation. It's mandatory. It involves no balancing of interests with the business. And here, I think she is probably right that the Establishment Clause was not the relevant consideration. It was Congress's concern for it was the EEOC's interpretation of a relevant concern for the welfare of business if required to deal with a wide variety of potential claims for accommodation. So we'll have to see, but we'll get a decision sometime in late June, I'm sure.
Yeah. Is there anything I haven't asked you that from the arguments that you thought needed to be highlighted, or did we cover everything so far?
I think we covered everything that is worth getting into, unless there are a couple things I might get into with my class that are really arcane and are not worth the time to try to figure out what's going on. And they're probably not even worth the time with them.
Well, I was going to say, I'm sure once we have the opinion, we'll have more to add to this conversation.
And let's talk again then.
Of course. I'd love to have you back then. Well, thank you so much for your time. I really appreciate it.
Oh, thanks, Alex. Always good talking to you.
The Supreme Court is expected to issue a ruling in Mr. Groff's case by the end of June. I'll have coverage of the ruling available on WashingtonTimes.com. Thanks for tuning in to the 9th episode of Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.